I'm not going to get fancy about this. I'm just going to read it as it is. I'm reading it from supreme.justicia or justia.com. And sometimes I read it. Sometimes it's cool because they have the like recordings of the actual session in court, which is always very exciting. But I'm just going to read the case, and I'm just going to read the first part of it. Schlesinger versus Holtzman, 414 U.S. 1321, 1973. Schlesinger versus Holtzman, number A 175, decided August 4th, 1973. 414 U.S. 1321, on application for stay. Syllabus. Application for stay of district court's order enjoining Defense Department officials from, quote, participating in any way in military activities in or over Cambodia or releasing any bombs which may fall in Cambodia, end quote. The only order extant in this litigation in view of Mr. Justice Douglas's order vacating Court of Appeals' stay of district court order ante P 414 U.S. 1316, granted by Mr. Justice Marshall, pending further order of this court. Berger, C.J., and Brennan, Stewart, White, Blackman, Powell, and Rehnquist. J.J. agree with this action. Mr. Justice Marshall, Circuit Justice. On August 1st, 1973, I, as Circuit Justice for the Second Circuit, denied an application to vacate a stay entered by the United States Court of Appeal for the Second Circuit on July 27, 1973, staying the order of the District Court for the Eastern District of New York dated July 25th, 1973. On August 2nd, Elizabeth Holtzman and others, plaintiffs in the original action, presented an application to Mr. Justice Douglas. A hearing was then set in Yakima, Washington on Friday, August 3rd. On August 3rd, an order was issued by Mr. Justice Douglas vacating the stay entered by the Court of Appeals on July 27, 1973, and thereby reinstating the order of the United States District Court for the Eastern District of New York. On August 4th, the Solicitor General presented an application for a stay of the order of the United States District Court for the Eastern District of New York. Since the action of the Court of Appeals in granting a stay is set aside, the only order extant in this case is the order of the District Court dated July 25th, 1973. The instant application calls on me to deal directly with that order in the District Court. In the ordinary course, a justice acting as a circuit justice would defer acting with respect to a district court order until the Court of Appeals had acted. But in the present circumstances, the Court of Appeals has already acted, and the consequence of the order of Mr. Justice Douglas is to set aside the Court of Appeals order. The consequence of the Court of Appeals' stay order of August 1st, 1973, was to preserve the status quo until it could act on the merits. The Court of Appeals, having originally expedited a hearing on the merits to August 13th, 1973, has since further expedited the hearing on the merits to August 8th, 1973. Now, therefore, the order of the District Court is dated July 25th, 1973, is hereby stayed pending further order by this court. I have been in communication with the other members of the court and the Chief Justice, Mr. Justice Brennan, Mr. Justice Stewart, Mr. Justice White, Mr. Justice Blackman, Mr. Justice Powell, and Mr. Justice Rehnquist agree with this action. Mr. Justice Douglas, dissenting. The order I entered August 3rd, 1973 in Holtzman versus Schlesinger not only vacated the stay of the Court of Appeals, but also reinstated the judgment of the District Court. I mailed it on August 3rd, 1973, and reported its contents to the clerk's office. My order of August 3rd, 1973 reads as follows. Order. On application of petitioners and after oral argument, it is ordered, 1. That the stay of the District Court's order entered by the Court of Appeals July 27, 1973 is vacated, and 2. That the order of the District Court of July 25, 1973, enjoining defendants from participating in any way in military activities in or over Cambodia or releasing any bombs which may fall on Cambodia, is hereby restored. W. O. Douglas, August 3rd, 1973. My brother Marshall, in his opinion of August 4th, 1973, misstates the facts when he says that, quote, the only order extant in this case is the order of the District Court, end quote. The correct statement would be that the most recent order in this case was my order of August 3rd, 1973, reinstating the order of the District Court, which would thus leave the Court of Appeals free to act on the merits and give full relief or, alternatively, permit this court to reverse me. Under my brother Marshall's order of August 4th, 1973, only this court can act to give injunctive relief. The court has unquestioned power to reverse me, and although I disagree with the court's action on the merits, that is not the point of this dissent. If we who impose law and order are ourselves to be bound by law and order, we can act as a court only when at least 6 of us are present. That is the requirement of the Act of Congress, and heretofore it has been the practice to summon the court to special term. Seriatim telephone calls cannot, with all respect, be a lawful substitute. A conference brings us all together. Views are exchanged. Briefs are studied. Oral argument by counsel for each side is customarily required. But even without participation, the court always acts in conference and therefore responsibly. Those of the brethren out of Washington, D.C. on August 4th, 1973, could not possibly have studied my opinion in this case. For although I wrote it late on August 3rd, it was not released until 9:30 a.m. on August 4th, and before 3 p.m., August 4th, I was advised by telephone that 8 members of the court disagreed with me. The issue tendered in this case was not frivolous. The government on oral argument conceded as much. It involved a new point of law never yet resolved by the court. I have participated for enough years in conference to realize that profound changes are made among the brethren once their minds are allowed to explore a problem in depth. Yet there were only a few of the brethren who saw my opinion before they took contrary action. Whatever may be said on the merits, I am firmly convinced that the telephone disposition of this grave and crucial constitutional issue are not permissible. I do not speak of social propriety. It is a matter of law and order involving high principles. The principles are that the court is a deliberative body that acts only on reasoned bases after full consideration, and that it is as much bound by the law of the land as is he who lives in the ghetto or in the big white house on the hill. With all respect, I think the court has slighted that law. The shortcut it has taken today surely flouts an act of Congress providing for a necessary quorum. A Gallup poll style type of inquiry of widely scattered justices is, I think, a subversion of the regime under which I thought we lived. One justice who grants bail, issues a stay of a mandate, or issues a certificate of probable cause cannot, under the statutory regime designed by Congress, vacate, modify, or reverse what another justice does. The court, of course, can do so, and only the court. But when the court acts, it must have 6 members present. Under the law as it is written, the order of Mr. Justice Marshall of August 4th, 1973 will, in time, be reversed by that higher court, which invariably sits in judgment on the decisions of this court. The order of August 4th, 1973, in this case would be valid only if we had the power to agree by telephone that the rules framed by Congress to govern our procedures should be altered. We have no such power. What members of the court told Brother Marshall to do on August 4th, 1973 does not, with all respect, conform with our ground rules. It may have been done inadvertently, but it is nonetheless not a lawful order. Therefore, I respectfully dissent. Part 1.